Mr. Hartel, I'm going to turn back to you now and allow you to make allocution.
Thank you, Your Honor. My client certainly doesn't deny the fact that he did commit some probation violations. He would ask the court for its mercy. If the court wishes, he, in a moment, is willing to put things in his own words for more perspective. But the summary of it is he did attempt employment multiple times. That didn't work out. I know it's, of course, not about excuses, but he has been attempting to get that employment. I do know that he does owe the totality of these fines, which looks very bad, and I will admit to that, but he has advised me he is willing to make at least a nominal payment today, which won't put a very large dent in it. But if the court were so kind as to give him more time, we're totally on board with the idea of extending this another year. We would just ask the court to extend the delay as well. He has advised me he will double his efforts in maintaining employment, making these payments, and successfully completing any treatments that he needs to do. Thank you, Your Honor.
Thank you. Ms. Carey, I'm going to turn to you. As I do, I'll make a statement or finding that pursuant to the statute, I cannot extend it again, so I won't. Ms. Carey?
And I'm going to ask the court not to give him the benefit of the delay. On the underlying offense was pretty serious and pretty outrageous. He self-reported he was blackout drunk at the time of the original offense. It is noted in the PSI, during the interview to the PSI, he came across as less than forthright. The underlying offense was pretty outrageous. And the money is clearly important, paying off the fines and costs. But the most important part of this was for him to get treatment and get help, which he has completely not taken seriously at all. And that should have been the focus, and clearly was not. So I'm going to ask the court to follow the recommendation and continue his probation without the benefit of a delay and have him found guilty of counts 1 and 2. Thank you.
Thank you. One moment. Mr. Mitchell, what is it you'd like to say to the court, if anything?
In my defense, I would say that I would have my fines paid off if the highway driver who held a position above me, he was like I don't know if he was a supervisor or what he was, but he told me to use the high-low, and so I listened to him. That was a mistake, obviously, because then my plant supervisor came and, you know, basically fired me on the spot. So, I mean, in efforts to try to pay off my fines, I'm currently in Big Rapids, like getting employment set up through Rent-A-Center. I got my chauffeur's license back in March, I believe. That way I could get like a better paying job and get all my fines paid off. Just the way things have been working out this year, I haven't really been able to get anything steady. I think once I do that, if you do give me the chance, I'd be able to have my fines paid off pretty quick. I don't have a lot of other responsibilities. I just, you know, just really these court costs and fines are like my biggest expense at this point.
Well, they're not expensive. They're not expensive. You don't pay them.
Sorry.
So I mean, you've got.
Yeah, no, you're absolutely
yeah.
right.
Yeah.
As far as the assessment, I was making my best efforts to, you know, join those classes every week and go along with the program, but I had missed like my 3rd day. After that, my probation officer, he told me that I hadn't failed out. And then by then it was, you know, I had like 2 unexcused absences and that kicked me from treatment. While I was going through the treatment though, I kind of did enjoy it. So I was sad that I didn't get to graduate from that course. I like Andrew and all those guys. But yeah.
Mr. Benak, well, I forgot to raise this, and I had this question last week. On the PSI update, CFJ 145, page 1, how come you don't list the 3rd conviction?
Sentence to,
Did we just put him on the delayed for counts 1 and 2?
yes.
Okay, all right, I missed that. Thank you. I know it does say if successful, counts 1 and 2 would be dismissed. Maybe what we should do, I'm going to ask you to do it. Amend CFJ 145, page 1, just to remind whomever looks at this later on that he was placed on the delay as to only counts 1 and 2. With whom were you living?
I was living with my friend Ataya.
Okay.
She's like a family friend.
And did you pay rent?
Like I would just like try to buy groceries and stuff.
Okay. How many hours a week were you working?
Once I finally established employment, I was working like 40 hours a week.
Okay.
I'm sorry, correction. So I was working full time, but it wasn't exactly 40 hours a week. It was so I'll just explain my schedule. It would be Monday, Tuesday, and I have Wednesday, Thursday off, and I work Friday, Sunday. And the next week would be alternate to
The court will preserve all fines and costs. The court revokes the defendant's delay under 771.1 parenthetical 2. I should have announced that first. Then when the court moves to sentencing, the first statement is the court preserves all fines and costs. For establishing any degree of reasonable grounds, we'll note that the defendant has failed to comply with his terms or conditions of probation. He has been given an opportunity. He had full-time employment at multiple instances and apparently had very little expenses as he wasn't paying rent, which means that the defendant was, to some degree, receiving a paycheck. And I see here that his hourly rate was, at least according to this report, up to $17 an hour. Therefore, the defendant may have the opportunity to pay for his fines and costs. He could afford to do so, but chose not to do so. The court places the defendant on a period of probation for 24 months. The defendant will have the right to be considered for early release from that probation after halftime if he completes all the terms or conditions successfully. Thus, if he is, after 12 months, successful in paying off his fines and costs and doesn't violate his probation, again, he'll have the right to be considered for early release. Now, because he's being placed upon a period of probation, the court must add to that additional $30 a month for supervision fees and $60 a month if there's any electronic monitoring, which was originally ordered. It's just obviously continuing for the next 4 months. Now, so far, that just leaves the court with the question of a period of confinement. Now, I look here at this. Not only has the court already identified that the defendant had the ability to pay but chose not to pay, additionally, the court notices that the defendant has been unsuccessful in his treatment program and his delay. He was given multiple opportunities and thwarted them. Many times I get before this court people who like to come up and say, well, I want to go to counseling. I was never given counseling. In this particular instance, Brady bent over backward to help the defendant get it, and he chose not to continue with that program. I also look at the Compass Needs Scale here that appears back in the original PSI, and he has a high probability for a few issues, but also a probable for several issues as well, including substance abuse, criminal personality, and so forth. And that is quite concerning to the court. The court also looks here at the defendant's conduct toward the law enforcement officers. And quite honestly, it doesn't surprise me that the defendant failed to be successful on his period of delay. When somebody is displaying such resistance toward authority, such as calling the police officers the names that he did and telling them what they should go do to themselves, Definitely does not seem to be a far reach from the defendant that I now see before the court. I see that the defendant had a prior, looks like he had a prior HYTA. And do we know if he completed that, Mr. Van Ackman? It says that you scored him as a misdemeanor for it, so I would assume that it stuck.
Agent Potter
All right.
wrote the original PSI. I did not follow up on.
Mr. Hartel, did your client successfully complete HYTA back in 2016? 17?
We're not sure.
Okay, all right. I also see here that the defendant had a prior conviction in 2021 that started out as an assault and resulted in a disorderly person, which appears to be what happened in 2020 in that file. I'm looking here at a defendant who now has further issues with authority and compliance. Oh, one moment. Mr. Van Ackman, what can you tell me about the defendant? Was he being tested while he was on this delay?
I reviewed our case notes prior to writing the report. I didn't see any testing entries.
Okay.
I don't know if he was testing through a third agency in Kent County. Sometimes those are not entered into our system.
Okay. I know that according to the report, he was compliant with testing while on bond. No, I've got an intermediate sanction cell. To be quite honest, I'm just trying to decide if I put the defendant in jail for 30 days. Quite honestly, with his had he made even a modicum of effort and making his payments, which he made zero, which means he didn't think it at all important. So, Ms. Manacourt, were there any payments made?
No.
All right. So we've got no payments being made. The defendant was given this opportunity. He had multiple chances to attend treatment. He missed multiple sessions back in October, again back, and then carrying on into November. I can't see here where the defendant treated this opportunity with the wherefore that he should have. Therefore, the court will place the defendant in jail for 30 days and give the defendant a 5-day jail credit. The court finds this to be proportional based upon the information as I've already described.